Yes, you're still under oath, sir.
Usasengaphansi kwesifungo mnumzane.
Yes, yes,
As the court, please, my lord, yesterday the state sought to cross-examine the accused on the confession made by accused number 2. The court then asked the state whether that is permissible.
Yeah.
And the state then addressed the court as to why it is permissible, namely that constitute executive statements, alternatively hearsay evidence that's in the interest of justice to be permitted. And we referred to the heads that we presented in the trial within the trial on the matter. Now the matter has been adjourned to today to give my colleagues the opportunity to address the court as well on that point.
Yeah. Okay, thanks. Mr. Nisi, do you still want to address the court?
Definitely, my lords. Because this case is not about me, it's about the accused. It's about Mr. Sibia and Mr. Nube.
Yeah.
Yes. Thank you, my lord. I'm just wondering if Mr. Sibia could be seated down whilst we are
Yes, sir.
entertaining the case.
Uyakhona ukuhlala phansi.
I would like to stand, my lord.
Thank you, my lord.
Okay. Yes.
My lord, this mine will not be a very lengthy thing. It will actually be a 4 or 5 minute thing. Now, what the state is requesting this court to do is what is known as austerity of tabulated legalism, which on its own is unconstitutional and against the principles of the law. Now, this is fundamentally legally flawed and incorrect. And the reason why I'm saying that simply because the state is basing their request on their misapprehension of the legal principles that are applicable in this area of this law. Now, which law are we talking about? We're talking about the executive statement in matters such as of this nature, a criminal case. Now, the common law is very specific with regard to the usage of executive statements in criminal matters. They are admissible based on common law, but however, there needs to be a determination. Now, the reason why I am saying, I'm sorry. Now, the reason why I'm saying, my lord, that the state's request is based on their misapprehension of the applicable principles of the law in this area of the law, it's simply because of what they are saying in their heads of argument. And I will simply refer to what they are saying in their heads of argument. In their application for in their response to the 174 application that was brought by or on behalf of Mr. Mapisa, and this is what the state says in paragraph 23 of their heads of argument, page 28, paragraph 23. It says, amongst others, that it is therefore submitted that the two confessions of accused number 2 can be classified as executive statements in the furtherance of common purpose and therefore an exception to the exclusion of an out-of-court statement of an accused. They are basically saying that the statements that were made by Mr. Ntanzi are confessions. That is what they are alluding to. Now,
Sorry. You're saying Mr. Nstanzi is accused number 4.
I'm sorry, my lord. The accused number 2, yes.
Oh, I see.
Accused number 2 is known for court. That is Mr. Ntanzi.
Okay, fine.
That is
Accused
beyond
number 2,
reproach.
fine.
Yes.
They're basically saying the statements by accused number 2 are confessions.
That is what they are alleging, yes.
Okay, fine.
Yes. Now, but in the same line, they are saying that they should be treated as executive statements. Now, that is exactly what I'm saying, why I'm saying that their request is based on a misapprehension of the legal principles that are applicable in this area of the law. Because a confession can never be an executive statement, and an executive statement can never be a confession. It cannot be the best of both. Now, when I'm speaking of best of both, I remember Albany bread. Yes, this very delicious bread, which is known as best of both. But this can't be a best of both. It is either a confession or an executive statement. The law is very specific, madam. Actually, this position and the state referred the court to that specific case. It's very succinct. That case of Mhlongo and Nkosi versus the state from the Constitutional Court that was decided on 25 June 2015. And immediately subsequent to that, a similar situation also arose, which necessitated the very same Constitutional Court to revisit this matter in the matter of Kanye and another versus the state in 2017. And the full citation of that case is 2017, Volume 2, SACR 630, Constitutional Court. A decision that was delivered on the 10th of August 2017 in the matter of Kanye and another versus the state. Simply the court in this regard said the situation with regard to executive statement is very clear. It cannot be confused with any other thing. It is determined by what the common law says. And common law says executive statement, yes, they can be admissible against other accused. But there must be a classification of the document that is sought to be used. Now, what is it that is before court that the state says they want to cross-examine Mr. Sibiya on? These are the documents that they are saying. These are the statements that the state is saying are confessions that were made by Mr. Ntanzi. I've already referred to a passage from their heads of argument in the 174 application where they are saying that these are confessions. Now, the law with regards to the admissibility of confessions in respect of another person is governed by Section 219 of the Criminal Procedure Act. And the position is very clear. A confession cannot be used against another accused person. The law is very clear. Now, what the state seeks to do here is to conflate issues, this to muddy the water, which is why I am saying that they are requesting this court to embark on what is known as an austerity of tabulated legalism, something very unconstitutional. Now, it is important, my lord, to classify the nature of that statement, whether it's an admission, whether it's a confession, whether it's an executive statement. Now, as I'm saying, the state, they are already saying in their own argument that these are confessions. However, they can be classified as executive statement. That is blatantly wrong. You can't. Because The legal principles that are governing these two sets of statements are totally different. Confessions are governed by section 219. Finish. You cannot take this position beyond that. If it's an executive statement, yes, then you can take the issue further. Then what this court needs to do, my lord, is to determine what is it that the documents that the state intends to use in the cross-examination of Mr. Ntanzi, which document, well, in the broader context of the case, I said were made by, which statement were made by Mr. Ntanzi. Are those confessions or executive statements? These questions need to be answered well in advance, even before the state embarks on the process of cross-examining Mr. Sibiya based on the content of those statements. Now, what is a confession? A confession is an unequivocal declaration of guilt. In other words, where the deponent of that document that constitutes a confession says, I am all yours, my lord. You can look at me, but on the basis of this document, you may as well say to me, I am guilty. That is a confession, unequivocal declaration of guilt. Section 209 is also applicable here because it says an accused person may be found guilty solely on the basis of his own confession. What is the content of the two documents that were penned by, that allegedly were penned by Mr. Ntanzi, my lord? And this submission, my lord, must not be construed to mean to validate the contestable statements that are still an issue before court here. I am simply referring to them because of this interlocutory application that has been brought by the state. As I'm saying, I am in no way trying to validate any contestable statements. I'm simply trying to deal with the substantive issues as they relate to executive statements and confessions and all issues around them. Now, it is uncontestable that in the two statements that Mr. Ntanzi penned, that accused number 2, Mr. Ntanzi, of course, penned, or allegedly made before Mr. Rapadio and the magistrate, Mefro Vivian Krunje. What are they? Are they executive statements or are they confessions? They are before court. Can it be said that on the face of those documents, Mr. Ntanzi can summarily be found guilty? Or can it be said that there are issues that still need to be ventilated around those documents? Now, what is a confession? I still remember when I was a prosecutor, we used to refer the court to this case of State versus Towa. I've tried to look for it, I couldn't find it. Towa. And there's this other case here.
How can you not find it? Sorry, how can you not find it?
Excuse me, my lord.
How can you not find that case, that authority?
I think I was let down by my system. I remember using an old-fashioned system.
Okay.
Yes, but State versus Kowa, it seeks to differentiate between or what a confession is. But again, there is this case of Likwareni. I think it's a matter from the Witwatersrand local division. North Gauteng, we used to call it WLD, my lord. I think that's where you started your practice, my lord, as a judge. At
Me?
the Witwatersrand, yes.
I know.
Thank
I
you.
started somewhere else.
Thank you, my lord. This Likwareni case, I think it's it's State versus Likwareni and others, in bracket SS 073 of 2015. In the
Who's
other
the judge, by the
brackets, excuse me, my lord,
The judge there.
that was Judge Spilch.
Yeah, he's next door. Spilch.
Yes, Spilch J, my lord. Yes.
Hello? Yeah. No, he's sitting here sometimes.
Thank you, my lord. Now, to some extent, it sought to try and demonstrate what a confession is, but in the broader context of what a confession is, or an approach in determining whether a statement constitutes a confession, they are saying an objective approach must be used. You don't look at one thing and then make a value judgment based on it. In other words, the entirety of the document must be considered. Now, back to the main question. These statements that allegedly were made by Mr. Ntanzi, what do they constitute? Do they constitute confessions or do they constitute executive statements? I may submit, my lord, without any fear of contradiction or of appraisal, that prima facie, those documents, and I've said I'm not validating anything, but the content of those documents prima facie constitute a confession. And if it is a confession, the story ends there, because they cannot be executive statements. They can therefore not be used against the other accused persons, my lord, because their position is governed by section 219 that says a confession by one person cannot be used against the other person. Then the state's application on those bases stands to fall off.
Okay.
Now, I've said, my lord, that I will not be long. I would therefore submit that on the state's own concession in their heads of argument that these are confessions, actually it should have actually ended there, because you cannot have a confession and an executive statement in the same line. No, either it's an executive statement or it's a confession. That will be my submission, my lord. Thank you.
Okay, thanks. Mr. Ramsepidi, you ready?
Indeed, my lord, I slept in the wee hours of this morning.
Please.
Try to bring this excellent document before court. As the court pleases, my lord, I'm indebted to the court for allowing us to go and prepare heads of argument, my lord.
Okay. Thanks. Yeah.
Now, my lord, my heads, I gave it the heading common purpose or executive statement exception, whether the state can cross-examine one accused on a confession of a co-accused. We say by way of background, my lord, that the state is busy cross-examining Mr. Sibiya, and in the process of doing so, it has signaled its intention to cross-examine Mr. Sibiya on the statement specifically my colleague referred to Exhibit JJ, which is a statement allegedly made by Mr. Ntanzi. So it signaled its intention to cross-examine Mr. Sibiya on that. And the essence of the state's argument, as I understood it yesterday, although today now they've added the second part, was that this was an executive statement made in furtherance of a common purpose. Now I hear today they are adding the second option that if it's not an executive statement, then it should be admissible against the co-accused in terms of the hearsay Evidence Act 45 of 1988, my lord.
Yeah.
Yes. Now, I'll come to this, my lord, but as a preliminary, we say that executive statements are those statements that are made by one participant to a conspiracy in the furtherance of a common purpose, and the rider is this, my lord. While that conspiracy or enterprise or common purpose is ongoing, and the executive statement is made in the execution of that conspiracy. And we say, my lord, and we must not be understood otherwise to say, those executive statements, if indeed they are executive statements, they are admissible against the co-accused, my lord. Now I'm setting forth the statutory framework in paragraph 2 of our heads, and we say, my lord, that the admissibility of confessions and admissions in the South African criminal procedure is governed by sections 217, 218, 219, 219 capital A of the Criminal Procedure Act of 1977. In brief, my lord, section 217 deals with the admissibility of confessions by the accused, which simply says a confession statement by the accused is admissible against the maker, that person. Section 218 deals with the admissibility of facts discovered by means of an inadmissible confession or statement. Section 219, and which is specific in this matter or in this argument, deals with the confession not admissible against another. And it explicitly states that no confession made by any person shall be admissible as evidence against another person. And section 219, my lord, deals with the admissibility of admissions by the accused. And then applying the legislative framework, we submit the following, my lord, that with respect to Mr. Sibiya, accused number 1, the state has tendered his alleged statement as a confession in terms of section 217 of the Criminal Procedure Act. The Honorable Court has ruled that this statement should be admissible as evidence in the trial within a trial. Furthermore, with respect to Mr. Sibiya, the state also tendered an alleged pointing out and an admission statement which, my lord, may either fall under section 219A or 218. Then with respect to Mr. Ntanzi, accused number 2, the state tendered 2 alleged statements made by him as confessions, and these 2, my lord, were ruled admissible evidence against as evidence in this matter. Paragraph 3, we just set a brief enunciation of the constitutional framework, and we refer to section 35(3) of the Constitution, which guarantees every accused person the right to a fair trial, which includes the right to remain silent and not to be compelled to give self-incriminatory evidence. Paragraph 4 of our heads, my lord, we set out in brief the relevant case law governing the issues that we are debating today. The first case that I refer the Honorable Court to is the case of S. versus Ndlovu and others, The citation is 2000 in paragraph 2, SACR 325, and it's a decision of the Supreme Court of Appeal. We say, my lord, in our heads that Ndlovu temporarily widened the admissibility by allowing one accused extracurricular statements to be applicable to other accused in terms of the Hearsay Evidence Act. We say, my lord, that the court in that matter invoked the provisions of Section 31C of the Hearsay Evidence Act 45 of 1988 and allowed the extracurricular statement of one accused to be used against the co-accused. And then there were subsequent cases, my lord, that followed Ndlovu as well in the Supreme Court, and we name them. They are S versus Ralukukwa, which is a 2008.
Sorry, is that Ravuku?
Ralukukwa.
Okay, fine.
It's 2008 in brackets 2.
Yeah.
SACR 394. It's a Supreme Court of Appeal decision. And there's a matter of Bulkwell, which is BALKWEELL. And another, this is the States, is a 2007, 3 All South Africa reports, 465, a decision of the SCA as well. And there's also the case that followed Ndlovu, which is Mamusha versus S, which is a 2007, volume 4, All South African reports. Paragraph 4.2, the Bulkwell case that we mentioned above, Supra, in the judgment of Justice Ponen, in an obiter dictum, this was not a ratio decidendi, but it was an obiter dictum. He questioned the reasoning and the validity of the Ndlovu SCA judgment and stated at paragraph 34 as follows. Ndlovu Supra makes an attempt to reconcile the incongruity, the bar created by Section 219 of the Criminal Procedure Act of 1977 and the application of Section 3 of the Evidence Act. Moreover, in dealing with the constituent parts of Section 3, Ndlovu offers no guidance as to how the receipt of the extracurricular admissions, which it allows under this section, should be approached at common law for the exclusion of what role, if any, the common law safeguards should play. And I close quote. Then paragraph 4.3, my lord, we mentioned that the case of Litako and others, which is a 2014 in brackets 2 South African criminal reports, 431 SCA, overturned Ndlovu, the Ndlovu case in the Supreme Court in 2014. And we submit, my lord, from our reading of Litako that there are 3 ratios that we can deduce from Litako case. The first one, and that is stated in Litako itself, my lord, at paragraph 445, paragraph H to paragraph I. And it says that the Ndlovu judgment was inconsistent with the common law. And the court stated as follows, and I quote paragraph 445, H to I, that the common law rule was not only an aversion to the admissibility of hearsay evidence, but it was developed because of the inherent dangers of permitting the use of extracurricular statements by one accused against another. It recognized potential conflict between the interests of the accused persons. Furthermore, because a co-accused cannot be compelled to testify, the common law appreciates that fair trial rights, including the right to fully challenge the state case, may be hampered. That is the first ratio. The second ratio, Decidendi, my lord, that we deduct from Litaco is this. It says that in Ndlovu, the provisions of Section 3.2 of the Hearsay Act were glossed over. And this we find, my lord, at page 445, paragraph F to G. And it states, in Ndlovu, the High Court, the provisions of Section 3 in brackets 2 of the Act, and by the Act they mean the Hearsay Act, were glossed over. That subsection provides as follows, that Section 3.2 in brackets, 3 in brackets 2 of the hearsay evidence provides as follows. The provisions of subsection 1 shall not render admissible any evidence which is inadmissible on any ground other than that such evidence is hearsay evidence. And the final ratio that we deduce from Litaco is the following: that the wording of Section 219 of the CPA, 219 capital A, my lord, sorry, of the CPA provides the admission of the evidence as stated at 446 H2I as follows. Evidence of any admission made extrajudicially by any person in relation to the commission of an offense shall be admissible against him. That is what we refer to when we are espousing the legislative framework. Now, I address the issue at point, my lord, which pertains to the executive statement. And we say in paragraph 5.1 of our heads, my lord, the executive statement exception has been succinctly articulated by the Constitutional Court in S versus Mutlongo, S versus Nkosi, 2015, what's this in bracket? I'll come to that, my lord. BCLR 8687 Constitutional Court as follows, and I quote, at common law, there is an exception to the exclusion of extracurricular statements of the co-accused if the statement constitutes an executive statement by an accused. It may be admissible against co-accused if it was made in furtherance of a common purpose or conspiracy. There must be other evidence, that is evidence aluende, to establish the existence of a common purpose before the statement can be taken into account. The state would have to pronounce on whether the common law exception survives a finding of constitutional invalidity of the admissibility of extracurricular statement of an accused against a co-accused. Now, my lord, at paragraph 5.2, we say, to give context of our admissions on this issue, we submit as follows, that it is essential to distinguish between an executive statement and a narrative statement. What constitutes an executive statement which is admissible against the co-accused, and what constitutes a narrative statement that is not admissible against the co-accused, but is only admissible against the maker. We say, my lord, executive statements are those statements made in furtherance of a common purpose, as stated in S versus Bondi or Bondi, NDI, 1962 in brackets 4 SA 671, a decision of the appellate division as it was then known at 678 D2F. That means to say, my lord, to qualify as an executive statement, the statement must be used, must form part of the data in the commission of the crime, which is what is called, it must be part of the res gestae, the facts, the commission of the offense, my lord. And we give an example there, but it is not, I must put a disclaimer, this is not my example. This example is found in Hoffman and Zeffert, my lord. And it says, for example, if A, B, and C are engaged in a common purpose and A makes a statement in furtherance of a common purpose, it will be admissible against B and C. And that was validated in the matter of R versus Mayet, 1957, 1 SA 492, and also in the matter of S versus French Baytech, 3 SA 438 at 432 and 433. And we said that this also extends to verbal declarations made during the commission of an offense where the perpetrators act in cahoots with each other. For example, if we are committing an offense and I see somebody come here and say, hide a knife, it constitutes an executive statement, and that will be admissible against my co-accused at the time who's present with me. And the further example at 5.3, also from Hoffman and Zeffert, my lord, it says, for an example, if A and B burst into a bank, as agreed by both of them, and A exclaims, and I quote, "This is a robbery. We will shoot at anyone who resists our demands and disobeys us." Then that incriminating statement, my lord, we say, although it is actually uttered by A, must be attributed to B as well, as it was part of the mandate between them, and it was also in furtherance of a common purpose to rob the bank. And we say, indeed, that statement will then constitute an executive statement because it will be used for the furtherance of a common purpose. And we give in brackets, my lord, examples of what may constitute executive statements. For example, declarations relating to coordination, to warning, to encouragement, or concealment, as I've referred in that example before. And we say, we admit, my lord, if they are executive statements, then they'll be admissible against co-conspirators, my lord. Now we compare these executive statements with what we term narrative statements, my lord. And we say narrative statements, on the other hand, are statements which are not made in furtherance of a common purpose, but rather as an account or an admission of past events, in which case they are not admissible against anyone else but the maker of that statement. And for that proposition, the case of Banda approves. It's S versus Banda and others, and 1993 SA 456B at 503 and 504. We say, my lord, narrative statements are not admissible against co-accused because admissions made in general are not vicarious admissible, are not vicariously admissible, but may be admissible against the person making them. Therefore, we argue, my Lord, any actions or statements made to carry out a common purpose can be relevant if they are accepted. They are considered relevant executive statements, meaning they are in furtherance of common purpose. However, such statements are not admissible, merely description of confessions about things that have already happened in the past and not in furtherance of a common purpose. And importantly, my Lord, and this will be found also in the TOI, that importantly, before an executive statement can be admitted as evidence, the existence of a conspiracy and the accused involvement in it must be proven by evidence aluende, independent evidence. At paragraph 6, my Lord, we say, importantly, a statement made after arrest does not fall within the exception because the common purpose no longer exists. And for this, my Lord, we quote the matter of S versus Mangena and Anada, which is a 2012 matter, 2 SACR 170 GSJ at paragraph 54. The court held that the admission of such evidence is based on a rational and logical inference, which is effective if the statement was made in furtherance of a common purpose. The court found that the timing, that limiting the rule in this way prevents the admission of an extracurricular statement made by one co-conspirator against another after arrest. The court noted that the principle appears generally in common law jurisdictions, as shown by the decisions of the U.S. Supreme Court. And in the court's view, the U.S. Supreme Court confirmed the exclusion of a statement made by one co-conspirator against another once the objectives of a common purpose are no longer being pursued or capable of being pursued. I want to refer the court to this American court that they cite. It's the matter of Krulevich versus United States, and I'll spell it. It's KRULEWITC versus United States. It's a 1949 USSC 33 336 USS 40 1949, and it was cited with approval in Wong as in Chinese, W-O-N-G, Wong Sun, that is, Sun is S-I-S-U-N versus United States. It's a 1963 USSC 15 371 US 41 at 490, 1963. And also they quote from a text by Wigmore, volume 4 at 1079. And I wish to quote what they said in that case, my Lord, if I can find it. Sorry. If the court can indulge with me, my Lord, I want to get the correct citation, the quotation from this American case. Oh, no, I know where it's at. Where's my quotation? I'll come back to that, my lord, before.
You want to quote this American case of 1949?
Yes,
They've given us the citation.
yes,
And then they quote this case in Wong.
in Wong, yes, my lord.
You know the case of Wong, 1962. Kentridge
Yes.
used this case in State versus Zuma.
Okay,
You remember that case? Where they say the past and the future.
Yes.
Kentridge was saying after this constitution, he quotes this case, Wong. It's East versus Zuma. Anyway, I'm with you there.
yes, because it says in essence that if an accused person is arrested and he gives a statement to the police and he was involved in a conspiracy with another accused, once he's arrested, what he tells the police does not become an executive statement,
Yeah, fine.
but it's a narrative statement. That is the essence of Wong and Krulevich, my lord.
All right.
Yes. Okay, and in paragraph 5.7 of our Hays, my lord, we say that to ensure clarity, it is important to stress that the common law exception continues as part of our legal system. And in S versus Mhlongo and in Nkosi, as quoted above, the Constitutional Court was asked to decide whether the common law rule permitting the admission of statements made by an accused outside of court in furtherance of a common purpose would violate the Constitution if used against a co-accused, but the Constitutional Court found on the facts that that matter was not ripe because the issues were not raised on the facts of that case. In paragraph 6 of our arguments, my lord, then we deal with conspiracy. And we say, in the case of Litako, at 450B to C, the court held that, furthermore, other than when one is dealing with the vicarious admissions or statements made in furtherance of a government purpose, neither of which are applicable in the present case, it is difficult to see how one accused extracurricular statement can bind another. At paragraph 6.2, my lord, we say, before the commencement of the Hearsay Act of 1988, an accused extrajudicial statement were admissible as an exception to the hearsay rule against a co-accused to prove the conspiracy or common purpose. And we say the exception fell under the vicarious admissions or the executive statements category. Now we come to the quotations that I said Du Toit mentioned in my previous address, that Du Toit at page 24 to page 50 submits as follows. For the following reasons, the common law exception have been abolished. A, Section 216 of the Criminal Procedure Act, which ensured their survival by applying the English common law, has been repealed by Section 9 of the Law of Evidence Amendment Act. Paragraph B, the specific treatment of hearsay in Section 3 makes it clear that hearsay cannot be regarded as a case not expressly provided for the purposes of the residuary provision. Section 225 of the Criminal Procedure has, in any event, expressly repealed, has been repealed by Section 9 of the new Act. And C, the Supreme Court of Appeal held that it was unnecessary for it to determine whether at the trial court as the trial court has held, the hearsay evidence in question could be received under the common law exception, in this case as an executive statement in furtherance of a common purpose, since, and we quote, the inception is not regulated by Section 3 of the Evidence Act of 1988. And at page 24 to 74, Dutoit deals with co-conspirators, which he says these are special cases. He says, Dutoit, the learned author, that our law has adopted the English rule that a statement made by A is admissible against B if A and B were associated in the commission of a crime, and the statement was made in furtherance of their common purpose. And he also cites with approval Mayet and French Beitach on that matter. Sorry, my lord.
French Bitter. Do you know French Bitter?
Sorry, my lord.
Have you heard of him?
French Beitach? I haven't, my lord.
You've heard of Trevor Huddleston?
The Reverend? Yes.
Very please. Trevor Huddleston is the Anglican bishop in South Africa. And he was a very active, liberal prince and priest. They arrested him for committing what the old regime used to call terrorism act. Collected money and gave it to Mkhonto Wesizwe to use to buy bombs and blah, 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 blah.
Okay.
French Peter.
So he was
I'm
charged
surprised,
under
Mr. Balui.
Now, listening with keen interest.
Oh, I see, okay.
So was he charged under the suppression?
Yeah,
Act?
he was charged, the first priest to be charged under the suppression of communism.
Yes.
Right?
Now, as we are continuing with the conspiracy, I'm leaving what the learned author Dutoit says. And these are not contained, my lord, in the heads that I've submitted.
I
so
see.
I'll submit from the bar, my lord.
Okay, fine.
We say, my lord, in a case of more than one accused acting with a common purpose, each is a conspirator liable under the criminal law for the acts of every other conspirator done in pursuance of the conspiracy. We've already quoted, referred to Mayet, the 1957 case.
All right.
And we said that the reception of such evidence is, I've already referred to this one, and I've already referred to the American case. And we say, my lord, that a statement made by an accused which falls short of a confession but amounts to an admission or other statement by the accused concerning his co-conspirators is as admissible against the latter, provided that it was made in furtherance of a common purpose. Now, the issue that I want to touch on, that's why I refer to this document, my lord. It's what Advocate Baloyi now says, that if the executive statement exception is not applicable, the alternative is that the Hearsay Evidence Act must apply, so that Exhibit JJ and the other exhibit, which are statements of allegedly of Mr. Ntanzi, must apply to the co-accused. And we say, my lord, the question, therefore, is whether the Law of Evidence Amendment Act allowed the introduction of such statement and whether it is constitutionally sound. If so, a further question arises regarding whether the admissibility of such statement is to be determined. Firstly, we say, my lord, the Law of Evidence Act, the Hearsay Act, did not in its terms purport to change the substantive rules of relevance. And we say, my lord, that the Ndlovu case that we cited, which was disproved by Litako, concerned itself exclusively with the application of the Hearsay Evidence Act and found that there were sufficient extraneous factors or evidence to ensure reliability of the extracurricular statement. The court in Ndlovu was not asked to consider whether the Law of Evidence Act expressly or by necessary implication extended the rule of reliability, which excluded any admission made by one conspirator against the other beyond the case where the statement was made in furtherance of a common purpose. Now we deal with what Mr. Baloyi seeks to do, that is to be allowed to cross-examine Mr. Sibiya on the evidence on the alleged statements made by Mr. Ntanzi. My lord, I must say that I was taken by surprise yesterday when Mr. Baloyi stood up and said he wanted to.
Who's that?
When my learned colleague, Mr. Baloyi, said he wanted to refer statement to Mr. Sibiya, which is a statement allegedly made by Mr. Ntanzi. And he wanted to cross-examine him on that because, my lord, we've had a trial within a trial in this matter. And at the trial within a trial, in respect of Mr. Sibiya in particular, when that statement was introduced, the state indicated that we are introducing this statement so that it is binding against the maker. At no stage where the other co-accused precognized to say, should the court admit this statement as evidence, then the rest of you, this statement is going to be applicable to you. Then it will give the other co-accused the chance either to challenge or to acquiesce with the statements made by Mr. Ntanzi. Now, to come up in cross-examination and to say, now that the statements are admissible, I'm going to refer you to this statement to bind you and to bind the other co-accused because this is an executive statement. And by the way, my lord, I submit without contradiction as well, that this is not an executive statement, and I'll show why I say that this is not an executive, those are not executive statements. And I'm also not going to give them a classification to say what they are, because the court has not indicated yet whether these are confessions or admissions. So I'm not going to be brave to say this is a confession, this is an admission. Now, to use the civil term, my lord, we say, at the time when the state says, I'm going to introduce, for example, JJ to bind you, Mr. Ntanzi, the term in civil law to say there was no lease between lease, not rental agreement, LIS, to say, Mr. Ntanzi, once your statement is admitted, I'm going to use it against Mr. Sibiya. I'm going to use it against Mr. Mngube, Mr. Mapisa, Mr. Ntuli, so that their lawyers could take the necessary legal routes to protect their client's rights regarding those statements, my lord. And with VEV, my lord, Kappa versus S is not applicable here because it puts a certain obstacle to the state, to the admission of this a hearsay evidence. Kappa says, before the close of the state's case, the state must make an application to court, which application will be debated by the state and ourselves, and the court will make a ruling to say, I want to make an application that this hearsay evidence and expounds that hearsay evidence clearly to be admitted against the accused before court. That was never done. The bus has already passed. Now, the submissions that we are making, my lord, to say that this application by the state must fail are the following, and I'm reading now from paragraph 7 of our heads of argument. We state, my lord, that from the principle enunciated in our arguments today, it is vividly clear that Exhibit JJ and whatever extracurricular statement that the state wants to cross-examine Mr. Sibiya on were made long after the offenses were committed. And we state, my lord, at the time the statements were made or allegedly made, the objectives of the alleged conspiracy as submitted by the state were no longer capable of being pursued. We submit, my lord, that such a statement or such statements are narrative statements because they are narrating past events after arrest. Because once we apply the Krulevich Wung Song, which say, and also Nkosi Mhlongo, which say, after arrest, any statement made is not an executive statement, but a narrative statement. And we say in this case, my lord, JJ and HHFF, whatever they want to introduce, my lord, and cross-examine on cannot be allowed because these are narrative statements which serve, if they indeed were made by Mr. Ntanzi and Mr. Sibiya, to incriminate the makers themselves, but not their co-accused. And I want to state, my lord, and I'll just briefly, as an anecdote, stop here. I want to be like Mr. Mnisi, to say, if I say the statement made by Mr. Ntanzi, I'm in no way saying he made it. I'm saying in the context of this argument, because tomorrow I know it will be quoted to say, during argument on the 13th of 2000, Mr. Ramasepeli stood here and said, you made a statement. So I don't want, on the right-hand side, when arguments come later, Mr. Ntanzi is held to the contents or the argument that I'm making specifically for this interlocutory application. And then I'm called never ever, everything never ever. And then paragraph 7 to 2, my lord, of our heads, we say we submit that to cross-examine Mr. Sibiya on the statements that they want to introduce does not fall within the exception because the co-accused at the time of the trial within the trial, or even in the versions presented by their respective counsels, have never by word or conduct accepted the truthfulness of what's contained in the statements that the state want to adduce and to cross-examine Mr. Sibiya or any other witness on. Paragraph 7.3, we submit, my lord, that the conspiracy on or common purpose ends upon the completion of a crime, arrest, abandonment of the conspiracy, or separation of the co-conspirators. And any statement that is made thereafter, my lord, is detached. (7.4), as I alluded earlier to say, executive statements are made in furtherance of a crime. For example, when somebody says we are together, say hide the weapon. we say, my Lord, that confessions are made to explain or to justify past acts. They do not advance the common purpose. And we say further, my Lord, that the common purpose exception should narrowly be applied, and specifically for matters that are done or said in the ongoing conspiracy, common purpose. They cannot be admitted against the co-accused under any guise, be it under Section 219, under the Hearsay Act, or under common law. Finally, my Lord, we say that executive statements are not even made to police officers. Executive statements are made to co-conspirators. And for that, for those reasons, my Lord, I say the application by the state stands to fail as the court pleases.
Okay. Sorry, what's the time now?
11:25, my Lord.
Yeah, okay, let's adjourn it. As Mr. Umalo is getting ready. Mr. Umalo, are you ready?
As the court pleases, my Lord, I did find the citation
Yeah.
that I was looking for.
Is this the one? Give it to...
Yes, it's a third case to the American cases, my Lord, the one of Fishwick versus United States. It's not there, my Lord. So I'm adding it on record, and it's FIS.
They've given you a colleague copy.
I'll give them a copy, my Lord. I'll give them a copy of what is not contained in the heads of argument, my Lord.
They're fine.
And the matter that I want to refer to, in addition to Kulavich and Hong Soon, my Lord, is the case of FISWICK Fishwick versus United States, 1945 USSC 134329 US 211 1946 at 217, and the Supreme Court stated as follows, my Lord. A confession or admission by one co-conspirator after he has been apprehended is not in any sense a furtherance of the criminal enterprise. It is rather a frustration of it. If, as the Second Court of Appeal sought, the maintenance of the plot to deceive the government was the objective of the conspiracy, the admission was made to the officers, it ended it. Okay. So far as each conspirator who confessed was concerned, the plot was terminated. He thereupon ceased to play an active role as a conspirator. His admissions were therefore inadmissible against the erstwhile conspirators. I'll give the court the citation, the registrar the citation, and my colleagues as well, my Lord. As the court cases.
Thanks.
My Lord, I've also prepared heads of arguments.
Okay.
Actually, thank you, my Lord, for giving us time to prepare for the heads of arguments. I'm still awake from yesterday.
Yeah.
My Lord, I've also made a copy of the judgment from the Western Cape High Court. It's State versus Lansing and others. The judgment was delivered on the 11th of August, 2025.
Okay.
I made a copy for the court.
Who are the judges there?
There's only one charge. Lekuleni DJ.
Was it?
Lekuleni.
Oh, okay, fine.
I find it useful, my lord, in this
Oh, okay.
application. My lord, I just had a conversation with myself that
With yourself?
yes, that this whole process emanates from my heads of arguments, which were filed on the 13th of August, 2025.
Okay.
So if one had responded much earlier, maybe we wouldn't have found ourselves from what we are facing with today.
I see.
Yes.
Okay, okay.
I was also surprised yesterday, I must say, my lord, because from my experience as a state advocate in the Eastern Cape and the KwaZulu-Natal High Court Division,
I can't hear you.
I was also surprised by the procedure that the state wanted to embark upon.
Oh, I see. Okay.
Yes, yeah, from my experience
Yeah.
as a state advocate in the Eastern Cape and the KwaZulu-Natal Division of the High Court, I haven't come across
I haven't come across that.
this procedure.
I see.
Yes. But coming back to my heads of arguments,
Okay.
under introduction, the gravamen, my lord, of this application arises from the fact that during cross-examination by the state to accused number one, the state intended to use a statement, Exhibit JJ, made by accused number two to cross-examine accused number one in order to establish the evidence aluende in the commission of the offense. Evidence aluende is evidence out of the statement that was made by accused number two, Mr. Ndanzi, before court. I must submit, my lord, that the defense vehemently object to this, as it violates the accused's rights in terms of Section 35, subsection 3 of the Constitution of the Republic of South Africa. The state alleges that the statement made by accused number two is an executive statement, as it was made in the furtherance of a common purpose or conspiracy. It was along that basis, my lord, that the trial within the trial was conducted for the admissibility of a statement made by accused number two before the magistrate, Ms. Cronje, on the 24th of June 2020 at Fort Loras Magistrates Court. The trial within the trial was conducted in order to determine the admissibility of that statement, as accused number two contested the admissibility of the statement on the basis that it was not made freely and voluntarily, but under threat of assault. The court nevertheless ruled that the statement was admissible and it can consequently be used to test the veracity of the contents. My lord, the defense responded to my heads of arguments, which were filed on the 15th of August 2025.
Yeah.
At paragraph 21 of the state's heads of arguments, in an application for a discharge of accused number 4 in terms of Section 174 of the Criminal Procedure Act 51 of 1977 as amended, the state submitted that the importance of not distinguishing between confession and admissions when used against another person means that the executive statements are admissible evidence against the co-accused if they are made in the furtherance of a common purpose or conspiracy. They made reference to a book by Hoffman and Zreffert, 4th edition at page 19, and contend that the book explained what is executive statements made in the furtherance of a common purpose or conspiracy, and they are admissible against the co-accused. In order to be admissible, the statement needs to form part of the acts done in the commission of a crime. I also did research, my lord, on this subject. And I came to the following with regards to executive statements. The executive statement of A, who acts together with B and C in the furtherance of a criminal enterprise, are, if they are performed in the furtherance of a common purpose, viewed as being not less than a statement of B and C. They may therefore be adduced against B and C if they have been made by those parties themselves. The statement by A is admissible against B because the statement is by law a statement that is attributable to B as much as it is to A. The state, my lord, therefore submitted that the two confession statements are attributable to accused 4 and the other accused, as much they are attributable to accused 2, and it can therefore be used to cross-examine accused 1 about the contents of Exhibit JJ. I submit, my lord, with due respect, that this is an attempt by the state to force open the door for the admission of such statements as executive statements against the co-accused, and this could undermine the integrity of the courts and our jurisprudence, and it should be discouraged at all costs. The common law exceptions. At common law, there is an exception, my lord, to the exclusion of extracurricular statements of co-accused if the statement constitutes an executive statement by an accused. It may be admissible against a co-accused if it was made in the furtherance of a common purpose. Executive statements, more commonly referred to as statements made in the execution or furtherance of a common purpose or conspiracy, is an extracurricular statement, out of court statement made by one conspirator that is admissible against the other conspiracy. The crucial element, my lord, is that the statement must have been made during and in the furtherance of a common purpose or a criminal enterprise, and not after the fact, like many confessions. My lord, what this entails, I'm going along the lines of my colleague's submission, Mr. Ramsepel. What the aforesaid statement means is that the accused must be arrested for having committed the offense, interviewed in respect of that offense, and a statement obtained from him, like in many confessions. The general rule is that a statement by one person is inadmissible against another in terms of the provision of Section 219 of the Act. I'll follow suit, my lord, and state that I don't want to validate that by mentioning a confession and validating the accused, that is accused number 2 statement, Mr. Ndans. I've dealt with executive statements. A confession on the other hand, my lord, is an unequivocal acknowledgement of guilt, equivalent to a plea of guilty in a court of law. In this regard, see R. versus Baker, 1929 AD, at page 167. The relevant definition of a confession is found at page 171. Such statements are admissible against their maker only. As stated at paragraph 3, my lord, when one was dealing with or the discussion of executive statements, they are made as part of an ongoing plan or execution of a crime. For instance, If one says, I've hidden the money at X location, that is an executive statement which is made in the furtherance of a common purpose or a conspiracy. This statement, which can be used as evidence against other members of a conspiracy because it is considered as an act of furtherance of a common purpose or conspiracy. Therefore, a post-crime confession of guilt by one person cannot be used as an executive statement to prove the guilty of the co-accused. The law treats executive statements and confession statements differently with distinct rules of admissibility and applications. Executive statements in the context of common purpose. The term is used to describe statements made by one party during the planning or execution of a crime that may be admissible as evidence against co-conspirators. These elements are part of the execution of a joint unlawful activity, not just a narrative of past events or an admission of guilt made after the fact. My Lord, I also found the useful case in this respect or discussion, the case of R versus Blake and Ty. It's an 1844, volume 6, QB 126. It's a UK decision. It provides, my Lord, an example of the distinction between executive and narrative statements. Narrative statements, my Lord, being confessions. And I've detailed the definition of a confession, which is an acknowledgement of guilty by the accused, equivalent to a plea of guilty in a court of law. For instance, in that case, a scenario was given in order to define the activities by the accused as executive statements and confessions. It reads as follows. The accused were charged with a conspiracy to pass goods at customs without paying duty. Ty, who was the co-accused, had made entries incriminating both himself and Blake in the two books. The entry in one of the books was part of the fraud, whereas the entry in the other book was solely the record of his own private purpose. It was held that the first entry was admissible against Blake as something done in the furtherance of a common purpose, as an executive statement. However, the second entry merely constituted evidence against Ty because it did not advance the common purpose, which is a narrative statement or a confession, which is not admissible against the other. In this respect, the learned author Swikat P.J. and van der Merwe, S.E., in the Principles of Evidence, 4th edition, at page 345, deals with the similar issues. My Lord, in State versus Lenting and others, in bracket, open bracket, CC08/2018, close bracket, 2025, ZAWCHC. It's a Western Cape High Court decision at page 341, delivered on the 11th of August, 2025. I must submit, my Lord, that the facts of that case, the Western Cape decision, are distinguishable from this case, but the principles in respect of the admissibility rules and the discussion on executive statements and confession statements are similar. The state, in that case, the Western Cape decision, submitted that in all circumstances, that so the contention proceeded, the evidence aluende, indicates that the statement of the three terrible Josta gang members acting in the common purpose. Counsel implored the court to admit the warning statement as evidence in the trial against accused 3 and accused number 14. The central question was considered, or to be considered, was whether a warning statement made by Mr. Sabtu, who was charged together with accused number 3 and 14 in the lower court, can be used as evidence against them in a subsequent trial in the High Court. In the instance where the maker of the warning statement is charged together with accused 3 and 4, and in this court in respect of the same offense. I've indicated, my lord, that the facts in the Lenting case are distinguishable from the facts of this case, in the sense that in the Lenting case, the court was invited to determine if a warning statement made by the deceased accused amounted to an executive statement made in the furtherance of a common purpose or conspiracy implicating accused 3 and 14. As a point of departure, it is necessary to emphasize that the fact that at common law, an extra cura statement of an accused was inadmissible against the co-accused. It is only in exceptional situations that an extra cura statement may be admitted not only as evidence against its maker, but as evidence against co-accused implicated thereby. The first is where, my lord, the co-accused, by his own words, asserts the truth of the statement to make all or part of the statement his own. The second exception applies to extra cura statements made by a co-accused in execution or furtherance of a common purpose or conspiracy. Such statements are admissible in evidence against any other person involved in the collusion. I now deal, my lord, with the arrest of accused number 2, Mr. Ndanzi, before court. On the 16th of June, 2020, the investigating team led by Brigadier Kininda, who is the head of the National Court cases, arrested Bongani Ndanzi, accused number 2. On the 19th of June, 2020, accused 2 made a confession statement before a commissioned officer, Colonel Rapaldi. On the 24th of June, 2020, accused number 2 was made a second confession statement before a magistrate, Ms. Kronyen, at Fostoras Magistrates Court. It was on the basis of those confession statements that accused number 4 was arrested. From the exhibit, my lord, that is exhibit JJ. The salient features, my lord, of the statement are that accused 2 submits that, the salient features, my lord, are that accused 2 statement, the state submits that they can be used to cross-examine accused 1 about the involvement of accused 4 in the commission of the offense are the following. That accused 2 used to work in Carltonville in 2014. He received a call from Sfison Dodi, accused number 5. He got his number from Mozi, accused number 1. They asked him to come to Basotho Hostel in Fostoras. He came to Basotho Hostel and Sfiso called him to the bedroom. I must mention, my lord, that, and I will stick to my heads of arguments, which I've already dealt with before this court. My lord, holistically, from the statement of Ndanzi, accused number 2, there is no passage in his both statements to the effect that on the 26th of June, he had met Constable Zungu at Basotho Hostel. The statement further goes on to say, while they were at the bedrooms, that is Fiso's room, Carlos Tosen Mapisa accused for arrived. Carlos and Tosen Mapisa then called Kelly. They told her that they were all right. We all then left in a Polo Vivo. It was accused one, Carlos, Tosen Mapisa, Fiso, and Muzi. From this, my Lord, there is no evidence that at some point accused number 4 was in contact. There will be evidence in Luede to the effect that at some point Mr. Mapisa, my client, was in contact with the so-called mastermind, Miss Kelly Kumalo. We then all got out of the vehicle. Sfiso was the driver. Muzi was the lookout. Mapisa was to stand by the window. Carlos and accused one was supposed to get to the house. In this regard, I submit, my Lord, that there is no evidence, independent evidence, from this confession statement to suggest that my client, accused number 4, at some point went inside the house after the 2 robbers had left the scene. Even the state witnesses, Ms. Zandile Kumalo, Tumelo Madala, and Mchogo Zesitwala did not make any reference to an individual who came into the house after the 2 robbers had left. The statement further goes on to say, he ran out of the house. As he ran out, Tosen Mapisa came in. He ran and got in the vehicle. They remained in the house. Obviously, the statement goes on further to say that they followed each other to a certain motor vehicle which had been parked at a nearby. In this regard, my Lord, one finds no corroboration or evidence alluende from the statement of accused number 2, that is exhibit JJ. It has been said, my Lord, that confessions are not admissible against another. Section 219 of the Act provides that no confession may be made by any person shall be admissible as evidence against another person. A confession of one accused may not even be used indirectly against a co-accused. What is meant appears from the judgment of State versus Batman. It's a 1960 volume 3 SA 535. It's an appellate decision in which the 3 accused were convicted of murder. One of them made a confession implicating the other 2. All that connected the confessor to the murder was his confession, and all that lined the other 2 was the fact that the 3 were in each other's company at about the time of the offense. Although the direct implications of the other 2 in the confession was therefore correctly left out of the cost considerations, Nana JA found on appeal that they were nevertheless indirectly and wrongly connected to the murder. There are so many cases, my Lord, that one can quote in this subject. I've dealt with them in my heads of arguments in an application in terms of section 174. One has in mind R versus Kosi and Zulu, 1950 volume 1, Prentice All Age 91, capital letter A in bracket, State versus Zerobe, 1968 volume 4 SA 420A at 425G, State versus Makeba, and another 2003 volume 2 SACR 128 SCA at 133 paragraph 14. There's also international law in this subject. I've dealt with this, the decision by Lord Felsham of St. Marisbon, Raspberry Law of Evidence, 4th edition, 1990, volume 2, 11, at paragraph 1131. which deals with confessions, that confessions are not admissible against the other. The Western Cape High Court decision, my lord, is useful in the sense that it discusses the Constitutional Court decision of State versus Mhlongo, State versus Nkosi, at paragraph 8 of the judgment.
Yeah.
It also discusses the cases of State versus Ndlovu, which was ruled unconstitutional. It discusses cases of State versus Letago and others, which is a Supreme Court of Appeal decision, which came with a different approach to that of Ndlovu, and confirmed the common law prohibition against the use of extraordinary statements against co-accused. That is at paragraph 16 of the judgment. At paragraph 24, the court, from paragraph 22, my lord, the court deals with the common law exception to executive or narrative statements. It discusses and gives examples, my lord, to the two statements, which are executive statements and confession statements.
Yeah.
In this regard, my lord, I submit that the statement that the accused, that is accused number 2 made, is a narrative statement, it's a confession statement. On the basis that the accused, as I've indicated, was arrested on the 16th of June 2020, he was interviewed by the police. He appeared before a magistrate, or before that, he appeared before Colonel Rapado for a statement, and ultimately, or subsequent to that, he appeared before a magistrate on the 24th of June 2020. And I submit that the statement that he made were about the past events, and he was narrating the past events which are detailed in those statements, which himself, accused number 2, contests. And those statements, my lord, I submit, are not executive statements and cannot be used. In fact, they are confession statements and cannot be used to elicit any information from accused number 1.
Okay.
I know there's one other issue that I would like to address while I'm still on the podium. The court will remember, my lord, that on the 17th of October, at the time when I was asking questions to accused number 1, there was an issue that I raised during cross-examination, the issue of Sinako Sibiya. This arose from the fact that Constable Zungu says when he was in the bedroom where Gwabeni was in possession of a .38 revolver. He then asked, Zungu says he then asked Gwabeni if, was it not the firearm that he had said he threw away in the river, that he had used to shoot or shot Sinako. Then the court, my lord, with due respect, made remarks that none of the defense counsel cross-examined Constable Zungu about what Constable Zungu was saying about Gwabeni, about the engagement between himself and Gwabeni. I had to go through the record, my lord. This was indeed done under cross-examination. In fact, it started, my lord, with my learned colleague, Advocate Mnisi, on the record of the 11th of September 2023, at page 97.
Yeah.
I'm raising this, my lord, because It seems as if one would want to say that since I have indicated before this court that the evidence of Zongo was that of a single witness and
Yeah.
there was no corroboration.
Yeah, we knew that.
Yes, but one would want to find that since Zongo had questioned Gwabeni about the .88 revolver, then that amounted to corroboration
Who says that?
by implication.
Who says that?
That is what I could read
No, no,
my
fine.
lord,
That's why I say who says that?
from the court's judgment. That is why I'm raising it now.
No, no. There's got nothing to do. It's a peripheral issue. Zoom is a single witness. We all know that.
Yes,
Yeah.
yes. But I just wanted to highlight my lord,
Yeah, no,
that
I hear you.
I just wanted to highlight this. This was done under
Yeah.
cross-examination.
But
This
just read it
appears-
for me. Alon. Just
This
read
appear-
that cross-examination.
My lord,
Just read that portion
yes,
with regards to the fact
It's a
that
record,
the firearm was thrown into the water. What?
yes. Thank you, my lord. It's the record of the 11th of September 2023,
Yeah.
on page 97, line 18. In fact, it's cross-examination by my colleague, Advocate Imnes.
Yeah.
And I quote, "Thank you. The very same Kwabene that you have told this court about will also come and tell this court that whilst you were in his room at the hostel, you further asked him if, after being handed with the .38 special firearm, you asked him if that was not the firearm which he said he threw away in the river after shooting at Sinako, using it." Then the response by Constable Zongo was, "I did ask him that."
Okay. So if I say that, it's a mistake.
I also,
actually.
because my cross-examination followed, my lord, on the very same subject, because I was not happy with the response that was given by Constable Zongo.
Yeah.
On the 3rd of October 2023, it's a record of the 3rd of October 2023, at page 34,
Yeah.
line 15. In fact, from this passage, my lord, I was quoting from the statement of Constable Zongo. I will start from, I'm sorry, my lord, I will start from line number 9, which read as follows. This is a quote, my lord, from the statement of Constable Zongo, Exhibit AA of the record. I then took the .88 special firearm from Gwabeni's hand and looked at it. I asked Gwabeni if it was not the same firearm which he had said he threw it away in the river after shooting Snako with the close quotation. Mr. Zongo, I hear that. The interpreter, which line is that? Mr. Ngumalo, it is line 9 and 10. Okay. But my lord, it's just a long passage, but I wanted to re-emphasize the fact that this issue was canvassed under
Yeah, fine.
cross-examination. It should
Okay.
appear from page 34, 35, 36,
Page 34, 35, 36.
36, 37, and 38 of the proceedings of the 3rd of October,
The
2023.
3rd of October, ne?
Yes, 3rd of October,
2023.
2023.
Fine.
So, my lord, in conclusion, then, I submit the following. It follows, my lord, therefore, that accused number 2 statement that he contested was made after his arrest on the 16th of June 2020 is a confession statement. It is a narrative of the past events and not an executive statement made in the furtherance of a common purpose or conspiracy, and cannot by its use as directly or indirectly against the co-accused in cross-examination.
Okay.
Those are my heads, my lord. They are dated the 7th of November,
7th of November.
2025 in Pretoria. Thank you.
Okay, thanks. Yes, are you ready? sorry, Mr. Ngomano. Do you know the Ngomanos in Soweto?
No, no, no.
Okay. You don't know the famous drum reporter who exposed the atrocities perpetrated on black peasants? They were farming potatoes using their hands.
Was it Nguman?
Yeah,
No, I'll follow on that.
famous gentleman.
Yes,
I schooled with the daughter Suzette,
is it?
pretty girl.
When was that?
Hello?
When was that?
Suzette, I schooled with her 1960
Oh,
in Madibane High. And the father, who, but a wee reporter, he was a reporter, as I say, Idram and Zong. And he's the guy who trained Abu Net Nakasa. You must know Net Nakasa.
yes, I've heard, I've heard.
Yeah. They hounded him out of South Africa and he went to teach in Swaziland. Amos SBs. You must ask your parents about the guy.
No, I will.
Abaningang abuzi aboduna musa.
It shows that we spend most of our time in Zululand, so
Is it?
Yeah.
Okay, no problem.
thank you.
It just struck me. Yes, ma'am. Nasive. You haven't written hits.
No, my lord. I will address from the.
No, I'm just asking.
Yes.
Yebo.
My lord, in response to the application by the state, my lord, I would like to respond as follows. Generally, my lord, the confession in terms of section 217, it's inadmissible against the co-accused. That's the general rule, which is also confirmed in the case of S versus Molim, 2008, volume 2, SACR 76. It's a constitutional court decision.
Yes, Bankabinde.
By Nkabinde, my lord. It's a standard rule which confirms the provisions of the criminal procedure and the constitutionality of those provisions.
Right.
That the use of a statement against the co-accused is unconstitutional, my lord. In this case, my lord, this honorable court has ruled on the admissibility of the statement that is an issue. And when the state introduced this statement, informed this honorable court that they intended to introduce the statement which was referred to as a confession, and the other one was referred to as a pointing out. And when a ruling, my lord, was made, this court, this honorable court, was guided by the provisions of section 217 and section 219 of the Criminal Procedure Act. And even the proceedings of a trial within a trial proceeded along those applicable provisions of the law. At no stage wherein it was indicated that such statements were the executive statement. And even when the ruling was given, my lord, it was not given that this statement is ruled admissible as an executive statement because it was not tried as such. And the trial within a trial was not done for the purpose of admissibility of an executive statement. So the submission that has been made by the state, my lord, which I would want to also read because it is contained in the decided case which my learned friends have referred this honorable court to, the case of Mhlongo and Nkosi, my lord. It's a constitutional court judgment on page 39. I'll just read the
Yeah,
two
fine.
lines. Yes, my lord. Common law exception. At common law, there is an exception to the exclusion of extracurricular statement of co-accused. If the statement constitutes an executive statement, close quote, my lord. If the statement constitutes an executive statement, the main issue to be decided, my lord, I submit, by this honorable court, is whether the statement made by accused, let me not say whether the statement made, because one day it will be said that I said the statement was made, whether the exhibits,
Who will say this?
the state, my lord.
Oh, the state.
Yes, the state, they will
Okay.
be saying that, yes. Whether the statements contained in Exhibit GG, Exhibit FF, respectively, my lord, before this court, constitute executive statement. If they are no longer the confession, they are now executive statements, then this case is applicable. But if they remain the confession and the pointing out, it means then that this case is misplaced because the statement that is before this court is not an executive statement. In other words, my lord, the state is doing what is called or what is referred to as trial by ambush. Introduce a statement as a confession, as a pointing out, then after the state case has been closed, the state makes submissions that such statement be referred to as an executive statement. My lord, there is a difference, a huge difference between the two statements. I will highlight just few differences between the two statements. Confession is made before a peace officer. Pointing out is made before a peace officer. Executive statement is not made before any peace officer or a magistrate, my lord, in terms of section 217 and 219 respectively. The point I'm trying to make, my lord, is the difference between the two and the circumstances under which these two statements will be made. Executive statement is not made before a magistrate, it's not made before a peace officer. That's the difference. Then now the statement, my lord, is before this court. Had we been informed from the beginning that these are the executive statements, my lord, the accused person would have defended themselves differently and appropriately. And as a result of the misplacement of this submission, the accused rights to the accused rights to a fair trial has been violated. Even if it has not been violated, my lord, but it will be violated if the court allows the state to use the statements contained in exhibits GG, FF, and HH against the co-accused. Their right to a fair trial will be violated, my lord. And it will render this trial unfair. And also their right to equality will also be violated. As a result, my lord, it is my submission that this court should not allow the state. I don't know the correct term to put, my lord.
To allow?
To allow the state to fish, you know, because the state is now saying it's a confession at the beginning. During the trial, it's an executive statement. Alternatively, it's a hearsay statement. It's a hearsay evidence. We're running 3 parallel regimes. And which one do we need to defend? The status of the evidence that is presented before court is very crucial, my lord, so that the accused will be able to defend that evidence appropriately. Even if because the problem, if that is not defined properly, the classification of evidence that the state is intending to lead, or that the state is leading, is that at the end of the day, the defense will be expected to make submissions on the admissibility of such evidence for the purpose of conviction now. And then if, my lord, the evidence is introduced as a confession, during 174 is introduced as executive statement, then our arguments, it is not clear as to what is it that we'll need to defend regarding that statement when we are doing the assessment of evidence now, my lord. I submit, my lord, with due respect, that the statement, these 3 statements, as they have been ruled, they do not amount to executive statements. The case of S versus Mhlongo, my lord, and S versus Ngosi, it's a constitutional decision case, my lord. My learned friend has referred to it. It's a 2015 well-known case, volume 2, SACR 323. And on paragraph 39, my lord, on paragraph 40 of this case. Open quote, my lord, on paragraph 40. It's a judgment by Theron AJ. It is not necessary to determine this issue. The facts do not arise. The extra crucial statements here were not executive in nature as considered by the state and will not fall under this exception. Determining this matter without any factual metrics to guide our understanding is unnecessary and undesirable. This question was not fully ventilated before us, and we thus have insufficient information to make a determination in this regard. We therefore thank His Lordship for the indulgence given to us so that we'll be able to ventilate this proper, my lord. To be able to make differences, make submissions on the statements that we're talking about. This paragraph, my lord, says, it is not, the exception that the state is referring to is misplaced because the extra crucial statement here that we're talking about now in this case, my lord, they are not executive in nature. Therefore, the exception is not applicable in this case. Because the statements that we are talking about, they are not executive in nature. They were not meant under the executive or for the executive purposes and the intention thereof. The state indicated that those statements were made under the provisions of Section 217 and 219 of the Criminal Procedure Act. And therefore, the exception that the state wants to rely on does not apply to the statements that are before this court. And they cannot be used against the co-accused, my lord. This is a constitutional decision. My lord, there is also a case of Ndlovu, which I do not want to go to dwell much on it because it was overturned in the case of S versus Litako, 2014 in brackets 2 SACR 431, its application.
Yeah, that's true.
Also, my lord, in my submissions, I also rely on the case of S versus Leting and others, which is also a Western Cape judgment, my lord. It's persuasive to this court, my lord, because it deals also with the constitutionality of the use of a statement made by accused against the co-accused. And it confirms that it is inadmissible. It violates a right to a fair trial of each accused. There is also another one, my lord. S versus Blake, 1844, it's English R, 603, 1844, 6, QB, 126, UK. All these cases, my lord, that I am referring this honorable court to, they confirm, my lord, that the statements made by the accused are inadmissible against the co-accused.
Okay.
The executive statement, just for argument's sake, my lord. These are the statements that are made by a party during the planning or execution of a crime that may be admissible as evidence against the other co-accused. The admissibility, my lord, I submit, the admissibility of that statement, the executive statement, is a complex issue. Although we're not dealing with an executive statement before this court, but I would like to make this submission, my lord. It's a complex issue that depends on specific legal rules regarding hearsay and a fair trial. So in other words, there are laws governing the admissibility of these two statements, my lord, executive statements and statements made under the provisions of Section 217 and 219. And it cannot be tried vice versa, my lord. And the usage as well of such statement is governed by the provisions of the Criminal Procedure Act, including the case law that I've referred to this honorable court to. Therefore, they are protected, the usage is protected. You cannot introduce a statement as a confession and then you want it to be admitted as an executive statement. Therefore, my lord, it is my respectful submission that the state should not be allowed to use the statement in exhibits FF, GG, and HH against the co-accused in this matter because they will suffer unfair trial, my lord. Those are my submissions. Thank you.
Okay. Thanks.
Sorry, my lord, there's one aspect that skipped my mind. I
What's
just
that?
wanted to address the court.
Yeah.
In fact, my lord, the two statements, executive statements and confession statements, you will find evidence aluende to the commission of the offense. One other issue is the case that the state referred to, the state case of State versus Sheikh 2007, volume 1,
Sheikh.
SACR
Okay.
247 SCA. It's a good example. I applaud the state. It is a good example where one finds executive statements because it deals with encrypted facts, and in that facts, certain unlawful activities were undertaken and certain individuals were mentioned. So it was said that it was done in the furtherance of a common purpose or a conspiracy. So the facts of the case of Sheikh are totally distinguishable from this case because, as I've mentioned, my lord, that it deals with the arrest of accused number 2 who was arrested on the 16th of June 2020, was interviewed by the police, and he ultimately appeared before a magistrate on the 24th of June 2020. And then in his statement deals with past events, the events that occurred on the 26th of October 2014. So the Sheikh's case does not deal with any past events. It deals with the contents of the facts and the activities that were detailed there. So one must not be misled by this case as having found support in these proceedings. Thank you.
Okay.
Thank you.
Yes, what's the time now?
6 minutes to 1, my lord.
You want to start now or after lunch?
We can continue after lunch, my lord.
Any counter review?
No objection.
Okay. Okay, until 2 o'clock then.
There's a quick business, my lord. We just want to briefly respond to the arguments that have been raised.
Awukakhathali na.
My lord,
Here the Mr. Smith.
let's be. What's over
Sibili.
I will sit, my lord, as and when I'm tired.
I was an athlete, a champion athlete. Ngabe sengifile.
My lord, the accused had indicated that.
What's that?
The accused had indicated that they want just a summary of the submission.
Yeah, no. No, they're entitled to it.
Just a summary.
Yeah, fine.
Phakathi kwale nkulumo ke bezikhona phakathi kwabameli benu nomshushisi noma ke inkulumo mpikiswano eyethe yavela noma ke eqala umshushisi izolo lapho khona efake isicelo sokuthi ucela ukusebenzisa ke istatement esabhaliswa ke ummangalelwa wesibili okuyena ke uNtanzi, kodwa ke kwatholakala ke ukuthi abameli benu nonke ngokulandelana kwabo bathi ke bona abavumelani ke nalesi sicelo ke esifake umshushisi ngoba ke asenziwa ngomthetho noma ke senziwa ngendlela ke efanele ngoba ekuqaleni uma ngabe eveza lesi statement wasiveza ngohlobo lwe-confession okuwukuthi kuya ngomthetho akuvumelekile ke ukuthi i-confession yomunye ke umangalelwa ingasetshenziswa ke ngomunye. Usike kwavela nephuzu ke komunye wabameli benu ukuthi kubalulekile ukuthi ke lezi itatimende zikwazi ukuthi zihlukaniswe ukuthi ziya ngohlobo olunjani. Kune-confession kukhona kanti ke futhi ne-statement umuntu esenza uma aqeda ukuboshwa, kanti ke kube khona ke i-statement lapho ke senziwa umuntu ekuchazeni ukuthi ke uma ngabe kwenziwa icala labantu abelenza ngenjongo efanayo. Futhi ke abashushisi bekufanele ukuthi ngabe bashilo isikhathi sesekhona ukuthi ke bazothanda ukusebenzisa lesi statement kubo bonke ke abamangalelwa phambi kwenkundla ukuthi ke nani nizokwazi ukuthi niziphendulele noma ke ukuthi nizokwazi ukuthi ke niphikisane nalokho nesicelo sabo. Ngamafishane ke abameli bathi bayanqaba ukuthi inkosi yenkantolo ivumele ke abashushisi ukuthi basebenzise lesi statement esabhaliswa umangalelwa wesibili kubo bonke ke abamangalelwa.
Yes.
As a court, please, my lord, just to address 2 issues, and the first one relates to argument advanced by almost all counsel that the common law exception of executive statement must be antecedent in nature. we submit, my lord, that that is not the only method, and in this regard, we wish to refer to the case of Rex versus Miller and another. It's a 1939 appellate division at page 106, and this, my lord, is demonstrated by the argument of Advocate Ngumalo when he quoted the Sheikh's case, indicating that the facts in question was written before the accused was charged. Looking at page 115, Author Mayor J.A. Essiden had the following to say. An examination of the textbooks shows that there is a well-recognized rule that the acts and declarations of one conspirator are admissible in evidence against another, provided that they are acts performed and declarations made in the furtherance of common purpose. Under this rule, admissions made by a co-conspirator after the purpose had been completed, consisting of a relation or narrative of some part of the transaction, have been held to be inadmissible. Then the Learned Judge of Appeal proceeds at page 117 as follows. It is very true that one mode of showing conclusively that a conspiracy has been entered into between various persons is by showing antecedent acts, and this is what counsel have been at pains to emphasize, as pointed in particular by Advocate Ngumalo. Or acts which may bring them together. But, and this is very important, Malo, but this is not the only mode. Another mode is by showing various acts subsequently in which they have concurred, acts done by them, leaving it afterwards to be inferred by the jury from the agreement or disagreement of those acts with reference to a common design, whether such common design existed or not. And just finally, at page 118, Author Mayor J.A. expresses himself as follows. If we ignore the word conspiracy and take a simple case arising in our law where A is charged as a socius in a crime committed by B, there are two elements for the Crown to prove. A, the acts done by B in the course of the commission of the crime, and B, the complicity of A in those acts. And my lord, this has been the high watermark of our argument, that the evidence of Constable Zungu shows that there was an association of the persons involved at the hostel, testified as to what happened before the departure of the accused, and also upon their return, how they followed one another, and as to what happened, accused number one handing the .38 to Gwabeni, and subsequently, while standing on a chair, announcing whether people have heard that Senzo Mewa has been killed. And if we take that, my lord, in conjunction with the evidence that has been tendered, in the pointings out and his own confession, my lord, the accused spells out the role that he played. He said his role was that of a lookout. We've heard the evidence of the witnesses who testify that those who were in the house, that they were in the house, 2 people burst into the house. They've identified at least 2 of the witnesses, my lord, Ms. Zandile Kumalo, Tumela Madlala, if I get identified, accused number 2. So one of the 2 persons who burst into the house, and accused number 1 spells out the role that he played, namely that of a lookout. We therefore, my lord, submit that if one looks at the evidence in totality, a picture emerges of executive statements. And then the second point, my lord, relates to the nature of the statements in question, or the status of the statements in question. Reference has already been made to the case of State versus Mhlongo. And we just wish to refer to page 333, where the court held that extracurricular admissions and confessions are hearsay by nature. Their probative value depends on the credibility of the person, the accused, other than the person who gave such evidence. And the court went on to hold that Section 3.1 of the Evidence Amendment Act codified the common law principle that stated that hearsay evidence was generally excluded. But in terms of the Evidence Amendment Act, Section 3.1 provides as follows, and we'll just refer to 3.1 subsection C. It says the court, having regard to the nature of the proceedings, nature of the evidence, the purpose for which the evidence is tendered, the probative value of the evidence, the reason why the evidence is not given by the person upon whose credibility the probative value of such evidence depends, any prejudice to a party which the admission of such evidence might entail, any other factor which should, in the opinion of the court, be taken into account, is of the opinion that such evidence should be admitted in the interest of justice. Those, my lord, are the 2 main legs on which the state argument rests, and we stand by the previous submissions.
Ushushisa uthi yena usamile ke enkulumeni yakhe ukuthi ke ngokomthetho uvumelekile ukuthi angakwazi ukuthi ke asebenzise ke lesi statement. Uyachaza ukuthi akuyona kuphela kusuyona kuphela indlela eyodwa engenza ukuthi mhlambe ke kulandelelwe abantu noma ke umuntu obhekene necala benze icala ngokwenjongo ke efanayo. Njengoba sekachazile ke wenze ke isiboniso ngamacala amaningi ke lapho ke kwakhulunywa lawo macala bese kwathathwa ke isinqumo ukuthi ke inkantolo inquma ngokuthini. Kuyasho ukuthi ke kumele ukuthi sibheke ke ubufakazi lo ke kulecala ke isibhekene nabo ukuthi ke Constable Zungu uyewasho mayinikezela ngobufakazi bakhe ukuthi ke kwakukhona ke iqembu noma ithimba labantu ebabehlangene khona lapho eBaswetini Hostel, lapho ke aveze khona ukuthi nomangalelo oqala wayekhona nomangalelo wesibili nomangalelo wesithathu. Washo wachazana ngendlela ke behambe ngayo, ngendlela babuye ngayo, ngendlela ke umangalelo oqala wabonakala ke edansa phezulu kwesitulo lapho ke esho khona noma ke ebhiyoza ukuthi ke uSenzo ubulelwe noma ke ushonile. Kanti ke futhi nesi statement asenza uma ngabe ke ehamba eyokhomba lapho egameni lapho kwenzeka khona isihlakalo uyavuma naye noma-ke ebufakazini bakhe kulezo yitetimenti lezo uyaveza naye ukuthi-ke abantu ababili-ke bangena lapho ngaphakathi kwendlu loko okuqinisekiswa-ke uZandile Khumalo naye-ke uTumelo Madlala ekushweni-ke ukuthi yebo kwangena-ke abantu ababili okuwukuthi bakwazi-ke ukuthi omunye walabo bantu kwawummangalelwa-ke yena wesibili uyasho-ke umshushisi ukuthi-ke uvezile ukuthi-ke ubufakazi obuthulayo ubufakazi obulethwayo ngendlela-ke yalezo yitetimenti lezo noma-ke kwi-confession ubufakazi vele ukuthi sizwe ngokuthi kungasiyinto eshiwo umuntu-ke ngaleso sikhathi ngokusho kanjalo-ke usamile emagameni akhe ukuthi-ke kuyilungelo lakhe noma kusemthethweni noma-ke ulandela imigomo nemibandela evumelayo ukuthi-ke kungasetshenziswa-ke istatement somunye-ke ummangalelwa.
What about the submission by Mr. Ramusepeli that an application should have been brought by the state before the state closed its case? And we quoted this case of, is it Kappa? Have you read that case?
Well, my lord, our submission is that the state presents evidence.
Yeah.
And the state may, at a later stage, rely on, it's like, pieces of a puzzle that should fit together. And the state may, at any point, rely on any pieces of the puzzle to say that the state must indicate its intention to rely on a specific puzzle beforehand. My lord, we submit that that is not in keeping with practice. We have presented the evidence. In fact, during the Section 174 application already, we signaled our intention, my lord, to invoke the doctrine of executive statements. And it cannot be said, my lord, that the state did not indicate its intention to rely on the doctrine when we clearly signaled our intention. And in fact, in our heads, mentioned that that is the doctrine on which we rely. We therefore submit, my lord, that should suffice.
And what about the submission by all councils that a confession cannot exist next to an executive statement because the status of a confession differs from that of an executive statement in the sense that a confession normally would be lodged or argued or presented in terms of Section 217.
Well, the court will recall that in our argument in the Section 174 application, we refer to the evidence of the case of Ditapo, which has been referred to, and the evidence of the case of Mhlongo. And in the case of Mhlongo, that has also been referred to, the Constitutional Court held that at common law, there is an exception to the exclusion of extracurricular statements of accused. If the statement constitutes an executive statement by an accused, it may be admissible against the co-accused if it were made in the furtherance of a common purpose. And in the case of Mhlongo, it was held that the distinction between a confession on the one hand and an admission is determined by the extent to which a statement implicates its maker, and held that there is no rationale why, when used against another person, there should be a difference in the admissibility of the two types of statements. And we also refer to the case of Ditako, where in the SCA held that from the perspective of the one accused who may be implicated in the statement of another, one strains to discern a sound jurisprudential basis for the distinction. So our understanding of these two cases, my lord, is that it's really not necessary to distinguish between a confession and an admission for the purpose of an executive statement.
And then the Taco, is that the case where Antahalta wrote the judgment, where there is a Tati and Moche? There were three, is that not so?
Yes, indeed.
And then-
There were actually four.
Four, sorry.
Yes.
It was who and who, by the way?
I don't have the names of the accused. I just know that there were four accused.
No, I'm talking about the judges.
Oh, the judges.
Yeah. Antahalta was overruled
Yes.
by Tati and Moche.
Yeah, I suppose it would have been the full bench of the
Yeah,
of the
quite.
SCA. Yes. Yes. We can quickly check who was on the bench.
Now I know Antahalta wrote that judgment.
Yes.
Hello? You got it?
I've got it.
Yeah.
It's
Who-
Nafza.
Who are the judges there?
Judge Nafza.
Hello?
Nafza and Ponan.
Nafsa and Ponan, okay.
Yes.
It's not the Taco. Let's see. Yeah. No, I'm quoting the wrong one. It happened in...
Northwest.
Hello? Northwest, ne?
Yes, in Northwest.
Northwest.
Yes.
That was that Moremio, the teacher who was
Yeah, around the town.
who reneged from his declaration. Why don't you seek with your computer, Antahalta, Moche, and Tati? SCA.
That will be Judge Makok.
Hello?
Judge of Appeal Makok, I think that's.
Was it Makoka?
Yeah, I think that is.
Yeah, Tati is Makoka, is it not?
Yes.
I thought Tati, that's fine.
The quorum was Supreme Court judges Nafsa, Ponan, Leach, Peze, and Swan.
Okay. Okay, fine, I'll have to check for myself. You say that one, what's the title of that one?
This one, Lord, it's dissertation. It's Moses Moshe Ditako. Ditako spelled L-I-T-A-K-O.
Right, it was in the Northwest, that case. Rustenbeck, if I recall.
Yes, in Rustenbeck.
Yeah. So you say that citation is who? Punan and?
It's Nafsa, Ponan, Leach,
Nietzsche.
Peze, Judges of Appeal, and
Yeah, Peter.
and acting Judge of Appeal, Swan.
Oh, yeah, Swan. Okay.
And it was heard on the 7th of March 2014, delivered on 16 April 2014.
All right, fine.
Yeah. It was, the trial took place in the Rustenburg Circuit Court,
Right, yeah.
and it was an appeal from the Northwest
Right, yeah.
High Court. Yes.
Okay. I spoke to some colleague and the SCA, but we can't wait for them. Apparently, there's an appeal on the same legal basis. This colleague of ours says he has written a judgment. I didn't want to read it because he says he's waiting for his two, three colleagues to assent or to tell him he's joking. Yeah, anyway, fine. I don't think we'll wait for him.
On which subject, my lord? Sorry.
The very subject.
Oh.
Executive, blah, 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 blah. The very same thing we're doing here.
Oh, okay. Yes.
No, I won't wait for him. I'll reserve judgment until Monday then.
That's a good thing.
Unless somebody wants to add something else. We are done. Okay, fine.
That next week I'm asking the indulgence to be excused.
So you won't be there on Monday?
Yes. But Mr. Ngumalo is standing.
Okay, fine. All right, let's adjourn until Monday.